Good afternoon, everyone. I'm Paul Gladen, Director of the Blackstone LaunchPad. Appreciate you joining us today to try to get some help navigating a bunch of the, well, two primary acts that have come out in relation to sort of the COVID-19 environment. And very pleased to be joined by Ross Keogh and Liz Mellem from Parsons Behle, and also Colin Boyle from Boyle, Deveny, Meyer, who are going to help us guide us through some of these, some of this legislation, and particularly deal with some of the sort of questions and topics and kind of edge cases that come through that. So I'm going to hand over first to Ross to introduce himself, and then we'll sort of go around the rest of our panel, and we'll jump into some content here. So Ross, thanks for joining us. You're on mute.
Thank you, Paul, and thank you, Morgan, for having us. And we're very excited to be here to talk about these very evolving and I think pertinent issues for a variety of Montana business owners and individuals. So today's webinar, we're going to focus on COVID-19 legal issues relating to both two pieces of legislation: the Response Act, which mandates different levels of coverage and engagement from employers, and also the CARES Act, and talk about some recent developments under the PPP loan program, and then some of the tax credits that are available there. During the webinar, feel free, if you have any questions, to pose those or direct those to Paul, and we'll be sure to get them answered as we go forward. So I do need to stress that this is, what we're providing here is potentially legal advice. And so I've been asked to sort of read the disclaimer here that things are rapidly changing. We are working extremely hard to keep up with all that is happening. This webinar is based on the available information as of April 30th, 2020, but everyone must understand that this is not a substitute for legal advice. If you have questions about the information contained in the presentation or how it applies to your business, then you should contact legal counsel. This presentation is not intended and will not serve as a substitute for legal counsel on these issues. And given the complexity and rapidly changing landscape, you must consult with your legal counsel on these issues. I'm going to introduce my colleague, Liz Mellem. Liz is the head of our Montana office here in Missoula, to talk a little bit about Parsons Behle, and then to jump into her section of the presentation.
Thanks, Ross, and thank you all for joining us. Parsons, Behle & Latimer was established in 1882 and is a regional law firm that's headquartered in Salt Lake City, Utah, but we have offices in Lehi, Utah, Idaho Falls, Idaho, Boise, Idaho, Reno, and our office here in Missoula. We help clients with a wide variety of issues, pretty much run the gamut from everything from IP issues and stock offerings to employment law issues and mining issues. There's a whole bunch of breadth of information that we can help with. If you want to go ahead and advance the slide for me, Paul. So I want to talk quickly about return to work plans now that Montana is quasi open for business. We know we're all in phase 1, and that means kind of a slow ramp up to getting back into business. I also want to address some provisions of the Family First Coronavirus Response Act that was enacted back a little over a month ago in the middle of March, and that became live on April 1st, and how it affects employers in Montana and Missoula in particular. The reason being is I've come across quite a bit of confusion about whether or not the provisions of the Response Act apply to Montana employers and how they might apply. So we'll go over a little bit of that as well. Go ahead and advance, please. Thank you. So initially, return to work. What does that mean? What does that look like for your business? Currently, under both state guidelines as well as the federal guidelines, the best thing for your company to do is to sit down and create a plan. You're going to need to figure out who returns to work. You may have laid off or furloughed, or have all of your employees sitting at home twiddling their thumbs waiting to come back. You may have a few people that are still in the office or at your physical location of your business, and you need to bring additional people back as you start to ramp up your process. So you want to determine who's going to come back, when they're going to come back, and implementing staggered or alternative work shifts. This is something that Governor Bullock recommends. It's also recommended by both the CDC and by OSHA. If you are able to allow your employees to telework, that is still highly encouraged and expected of most employers to continue doing. In addition, if you cannot maintain social distancing among your employees, for example, you own a restaurant and it's hard for your cooks and your servers to be separate because they're passing each other in the kitchen and they're handing dishes off to each other, consider reducing your workforce, reducing the amount of people that are available on any shift and staggering the shifts. Also implement personal protective equipment and social distancing for your employees and your customers. Many of us in Missoula have experienced this if we have gone to local retailers, in particular grocery stores, who some have one-way aisles right now to encourage social distancing. Others have markers of where you're supposed to stand in order to be in line to maintain the social distancing. Those are things you want to consider for your business. You also want to look at the OSHA guidelines and CDC guidelines about cleaning. There are ramped up and important guidelines regarding which chemicals and sanitary items you can use to sanitize workstations, to sanitize the front door of your business that customers and employees might be going through, those sorts of things. The EPA and the CDC has a list of, I believe it's over 300 approved cleaners that will work in this environment and that will help with sanitation. You want to set up cleaning and sanitation schedules so that your employees know how they're supposed to be cleaning, when they're supposed to be cleaning, and what they're supposed to be cleaning. For example, Governor Bullock's Phase 1 order that allows breweries and bars and restaurants to open soon also requires that, as one of the many guidelines and limitations to reopening, requires that once a booth or a location is vacated by your customer, it has to be completely cleaned. The high chairs, the seats, the table, more, all of the salt and pepper shakers, more than what you may have been used to normally. So be aware of that, make a plan for it. The last point on this slide is about safety huddles. For those of you who are in the oil and gas industry and the construction industries, you know that this is something that you do on a regular basis already. But for other industries, this is brand new. This involves, being done by Zoom. It does not involve necessarily physically huddling, but talking about what issues are arising with cleaning, what people are seeing, what instances are occurring, and best practices for going forward and how to address them in the business. Please advance the slide. So in addition to creating a plan, you want to make sure you're communicating that plan to your employees, right? That you're training your employees on it and that they know what's expected of them and what you're going to be doing to enforce that plan. You want to have plans for checking temperatures. There are there's guidance from the EEOC regarding that temperature checks, while not normally allowed of your employees in this current pandemic, is allowed. You also are allowed to do temperature checks of individuals entering your business, of your place of business. So all customers, for example, if you run a dental office and a client comes in because they need some sort of emergency procedure, you are able to do their temperature check and screen them for symptoms before they come all the way into your office. The screening for symptoms, stay up to date on the CDC's expanded list. That includes now loss of taste or smell, as well as chills and a high fever and the cough and shortness of breath that we have all been hearing about now for several weeks. Make sure also that you have a plan for how to respond to symptom demonstration. So if you hear someone coughing, if you see someone that looks flushed and you check their temperature and they have a temperature, how is your business going to handle that? What are they going to do? What are you going to do to protect not only that employee, but yourself, your other employees, and any clients or customers who may be present? Figure out how you're going to address contact tracing and isolation or quarantining of those individuals, how you're going to work with the local public health department about the contact tracing, and how you will respond if you have an individual who refuses to return to work because they are concerned about their exposure or potential exposure. So, for example, the phase 1 portion of Governor Bullock's reopening plan for Montana talks about continuing to protect vulnerable populations and making accommodations for your vulnerable employees. Right now, there is a very interesting mix between requirements from the American with Disabilities Act, the ADA, as well as the EEOC, in order to try to avoid discriminating against any individuals, but also making sure you're protecting individuals. The current hotbed of questions and issues and where you really want to be careful is when you have workers who are of an advanced age. You want to make sure that you are not doing anything that may discriminate against those workers based on the fact that you perceive or know that they may be older than 40 years old, which means they are a protected class under Title VII of the Civil Rights Act, but they are also considered a vulnerable population in this current pandemic. So make sure that you are appropriately approaching those situations and accommodating those situations. And that is something that certainly legal counsel can help you walk through. The last piece, of course, for your plan is how to manage the leave that is requested and required under the Response Act. So we'll get into more of those details here. Paul, if you'll advance the slide, please.
Liz, can I ask a quick question? You may address this later as well. There's also been some discussion in terms of this sort of reopening around liability for businesses. So some of these things sound like they're guidelines, some are requirements. What advice do you have in terms of, I guess, not only trying to have the plan and implementing the plan, but is there things they should be doing to sort of record the fact they're doing these things?
Definitely. That's a great point, and thank you for asking that. One of the primary things that you want to remember with creating a plan is that you are documenting. You're documenting the plan, you're documenting who knows about the plan, who's been trained. It's very similar to other administrative aspects of the human resources part of your business. It helps if you determine who's going to be kind of your COVID-19 team leader, and that person will be in charge of administering the plan, documenting, keeping the records. For example, under the Response Act, when leave is requested, those records have to be maintained for 4 years. So there is quite a bit of documentation that should be done and maintained. The plan, as this slide indicates, will help reduce liability risk, both for the employees and customers. It helps you implement a standard of care in your business, and this comes a lot from consulting industry best practices. So if you're a restaurant, you talk with your local restaurant authorities and associations. If you're a mining company, you do the same thing. You really make sure that you are following what the best practices are. In terms of immunity statutes, as is indicated on this slide, currently the one I'm most intimately aware of is Utah, where I'm also licensed to practice law. Recently, the Utah governor called a special legislative session, and the legislators passed a law that allows or provides for immunity of employers and businesses from any claims related to COVID-19 illnesses or injuries, as long as that business was not willfully disregarding their obligation to clean, as long as they were doing their best and trying their hardest. Now, there's a side issue about whether or not that law is actually going to end up standing in Utah, but I can tell you that from the Montana perspective, I don't see anything like that coming in the Montana future. It's not something that I would anticipate the Montana legislature takes up in the next session that's coming up in several months. I can't see a special session being called. So it is something that employers need to be aware of. There are several different class action lawsuits across the United States right now, mostly against big retailers for their failure to provide PPE to employees or for their failure to adequately protect customers. So having a plan, documenting the plan, and following the plan and enforcing it with your employees will go ahead and help the employers in that sense. In terms of immunity statutes on a federal level, we're not quite there yet. I don't know that we will get there with this current Congress that we have. However, things are changing so quickly, and we're seeing so many laws come out of this that it's possible that we may see something on a federal level. That, of course, doesn't change the state level considerations, but it may be there. You can go ahead and advance to the next slide. So talking overview quickly of the Response Act. So the first bucket of leave rights, this is the emergency paid sick leave portion. The two portions of the Response Act that are really relevant that the employers need to be aware of are the requirement to provide paid sick leave on an emergency basis related to COVID-19, and also the requirement to provide expanded or additional reasons for family medical leave under FMLA. So this first part is about the paid sick leave. This is up to 2 weeks of pay for an employee who's subject to a local quarantine or isolation order, has been advised by a healthcare provider to self-quarantine, is experiencing COVID-19 symptoms, and is seeking a medical diagnosis. That third bullet point down is important. The employee can't just call up and say, oh, I think I have a fever and I kind of have this cough, I need 2 weeks off. That's not the way it works. They do also need to be seeking a medical diagnosis and be able to eventually provide you documentation of that as their employer. There also is the possibility for someone to receive 2 weeks of pay if they're caring for someone else who has one of those first three instances. For example, they're caring for someone who is under an isolation order or has been advised to quarantine. The second bucket of leave rights on the next slide, if you would, Paul, is regarding family medical leave. So this is where there has been a lot of confusion, in particular with small employers, because generally the Family Medical Leave Act only applies to employers that have 50 or more employees under very certain circumstances. So there's a couple of different bullet points to figure that out. But a lot of employers, especially in the Missoula area and in Montana, say, well, yeah, family medical leave doesn't apply to me. I only have 5 employees, or I only have 10 employees. Under this new law, this limited portion of family medical leave does apply to employers who have even 1 employee. All that's required is that the employee has been employed for at least 30 days prior to them requesting the leave. So under this portion of the Response Act, the Family Medical Leave Act is expanded only to allow an additional reason for leave, which means that an employee can take up to 12 weeks of leave because the employee is caring for his or her child whose school or daycare has been closed due to COVID-19 related reasons. For everybody in Missoula right now, I think MCPS may have made the decision, maybe not, but at least in the Hellgate School District, they're closed for the rest of the year. There's quite a few daycares that are closed, so there are a lot of employees that are going to be able to take this kind of leave. The small business exemption that is in the Response Act only applies in this very narrow, limited situation. There's been a lot of confusion in the community about people saying, oh, well, there's this small business exemption in the Response Act. So since I'm a small business, because I only have 5 employees, I don't have to pay any of this. That's not true. The only way that this exemption applies is if an employee is requesting leave for the purpose of caring for their child whose school or daycare is closed due to COVID-19. The employer has fewer than 50 employees, and the employer can show that it would be significant economic if the employer allowed this or paid this kind of leave. There's a 3-factor test that any legal counsel can walk you through and walk through your options there and whether or not it would apply to you. Basically, it has to do with whether you can continue to operate at a minimal capacity, either because the employee who's requesting the leave is so vital to the business that the business just allow them to be gone, or there aren't sufficient other employees to make up the slack for them, or paying out the actual leave will causing substantial economic harm to the business. So it's a very limited exemption, but it is available. It is something that legal counsel can go through if you might apply to your business.
Liz,
oh yes.
Sorry, this is Morgan. You're cutting in and out a little bit. I don't know if you're able to lean in. Yeah, that's okay. And then I have a quick question from the chat if I can interrupt you.
Absolutely. What's up?
Okay. So this is from Laura. I have an employee who is responsible for taking care of her children from 8 to 1 and then works with me 1 to 6. Can I pay her the 2/3 pay for the 12 weeks for when she is taking care or teaching her children?
And Liz, this was actually one of the questions I shared in the email earlier in the week in terms of can you split between?
Right. So it's a good question, and it's something that is possible for it to happen. I would want to know more about the situation, more about the business, because, for example, one thing that I don't have in the slides here is that an employer who employs healthcare providers has the ability to potentially exempt their employees from this type of leave. But in addition, depending on what the policies are at the company for their normal paid leave, whether that's sick pay or vacation pay, they have the ability to work with the employee to allow them to take this 2/3 pay for the 12 weeks and supplement that with their PTO. But it's a tricky situation when the employee is already partially working. It also comes into play whether the employee is salary or hourly. If they're a salaried employee, it's a much different situation than if they're hourly and you're paying them those minimum hours.
It looks like this case is hourly.
Okay, yeah, so that would make it slightly easier, but it's not a clear-cut or straightforward thing that I would feel comfortable saying, yes, go ahead and do that, or no, don't, without being able to speak directly to the person. So it's something I would definitely advise them to get some legal advice on. If they wanted to, they can go to the Department of Labor website, which is just DOL.gov. And there is a list of frequently asked questions that goes over several of these topics. It can be a little cumbersome to scroll through because there are so many of them, but it does give quite a bit of information for employers to sift through on their own. And then if they have additional questions, they can reach out to their legal counsel.
Okay, it looks like she hasn't found the answer. So I'm gonna have Liz continue, but Laura, it seems like Liz's advice is to go to your legal counsel and get really specific advice on this hourly case.
Yeah, and unfortunately, I know that's something employers don't want to hear. They don't want to hear that they have to go pay an attorney to talk about this stuff. But unfortunately, with these laws being so new and all of a sudden employers having to give paid leave, which is never something our federal government has ever required, it's such a new and changing landscape that you really want to make sure that you are getting good advice and that you are working with your legal counsel to protect your company moving forward.
Okay, awesome.
Paul, could you advance to the next slide for me? So these are just examples of the leave rights that you can have. The bucket 1 leave rights, those give your employee the full pay, basically when they are directly impacted by the COVID-19 issues, they're experiencing symptoms and seeking a medical diagnosis, or they themselves are having to quarantine. They get their full pay for up to 2 weeks, and that's capped at $511 daily or $5,110 total, and that assumes 2 business weeks of 5 working days, so a total of 10 days. The second bucket, where they're caring for a child, that is where it's capped at $200 a day, or $12,000 total. And the total is bigger because it spans for a longer number of weeks under the Family Medical Leave Act. The eligibility for these, emergency paid sick leave, that's immediately available to your employees. If you hired them yesterday and they worked today and tomorrow they call and say they've got COVID-19, healthcare provider has told them to quarantine, they are entitled to sick pay. The laws passed by the federal Congress are pretty stringent and a pretty big change and shift for employers. The second bucket, as I mentioned earlier, for FMLA leave, that is only after the employee has been with you for 30 days, but it's not the normal onerous FMLA leave test. So all that requires is 30 days. Your best bet here is to create and distribute a policy to your employees that explains to them when they are eligible for this kind of leave, when you're going to pay it, what's required of them to give you. We do have policies that we can tailor to fit your specific business. If you wanted to reach out to us, we can help with that. I know that there are generic policies that have been posted online that you can look at. I never recommend using those without the advice of legal counsel because you don't know if they're going to be accurate for your jurisdiction. But they are places that you can get an idea of what will be required and what would be good for you. You can advance, please, Paul. So I'm going to try to quickly move through these next slides because I know I've taken quite a bit of time. These are basically reminders regarding reductions in workforce. If you haven't yet reduced or you are going to reduce your workforce, I want to give the giant caveat that both Ross and Colin can explain a little bit more about after this, is that if you have taken or are taking a PPP loan, make sure you talk with your legal counsel before you do any sort of reduction in force, because it can affect your ability to have that loan possibly forgiven by the federal government. You want to be very careful about what you're doing there. In terms of a RIF, you want to make sure that the plan is in writing, that you're stating that you're doing it because of the financial distress facing the company and the current economic situation, and that the financial situation is going to be resolved in part by the layoffs. Give some clear criteria for forming the basis of the decision so that it does not appear or is not in reality being done in a discriminatory manner. It doesn't matter what departments they are, but you want to focus on skill sets of employees. Generally, the last hired can be the first fired. That's kind of a pretty easy rule for employers to go by if that's what they want to use. But really, you want to make sure you're doing this in the way that you're not somehow either unintentionally or intentionally eliminating all women, or unintentionally or intentionally eliminating everybody that's over 40 years old, because that will get you into hot water federally. It also will get you into hot water on a state basis in both Montana and Utah, the places where I am licensed. If you'd advance to the next slide, please. With the ensuring that it's not discriminatory, you also want to make sure it doesn't have a discriminatory impact. That can be determined very easily by creating a plan, figuring out how many employees in each department are of a particular gender, a particular ethnicity, or a particular age. You want to make sure that you minimize the risk of a claim of discrimination, and documenting your careful process and why you selected people based on the objective criteria will help you with that. Once you have all the employees selected, you again make sure that there's no discriminatory impact, so that for some reason it isn't that, you know, all of the people that you've hired in the last 30 days are the only people you're going to lay off, and for whatever reason all of those people are women who are not white. That should be a red flag for you if that's who you're eliminating, even if you are following the criteria that you laid out. So you want to make sure that if you have in-house legal counsel, they are part of the process. If you don't, consult outside legal counsel if you're worried about anything that you might be doing when you're reducing your workforce. Go ahead and advance the slide, please. And then make sure that no one that you're trying to reduce has engaged in any sort of protective activity. So for example, if someone has asked for leave under the Response Act, and you decide that they need to be part of this reduction in force, you need to make sure that you have fully documented that you're reducing them based on these other criteria and not because they asked for that paid leave. Also, that they haven't made a harassment or discrimination complaint, that they might be able to turn around and say, well, you know, I told our HR manager a week ago that so-and-so was harassing me, and then all of a sudden I was one of only 2 employees that got laid off. That would be very suspicious circumstances that they could make a lot of hay out of, that you don't want to have to deal with as an employer, and just a little bit of extra care and documentation will help protect you there. Go ahead and advance the slide. And then in this case, you want to make sure whether or not anybody has any employment agreements. So as we all know, Montana is different from every other state in the United States in that we are employee friendly, not employer friendly, by protecting employees once they go past their probationary period. Make sure you also don't have a separate agreement with them that requires for-cause termination or specific severance. And that you are making a good documentation of the business need for reducing them from your workforce. Go ahead and advance, please. And then making sure whether or not there's any other pay or benefits. For example, in Montana, as soon as you terminate someone, you have to pay out their accrued time off. Montana is not a use it or lose it state. So you can't say, oh, well, you never used it, so it goes away. Once the employee accrues that time off in their paid time off bank, it's theirs. It's considered a wage and it has to be paid when they're fired or when they're terminated. Also make sure whether or not if you have a health plan that you allow or provide to those employees that you're giving appropriate COBRA notices, and your healthcare plan administrator can help you with that. Go ahead and advance. And then just the final piece from me is that if you are a business that has more than 100 employees, which in the Missoula area we consider to be a large business, if that's the case, there is this fun little thing called the WARN Act, which requires you to give advance notice of 60 days potentially to your employees prior to doing some sort of layoff. There are exemptions and exceptions to that, and legal counsel can walk you through that, but know it's out there, know it's a landmine if you are at a level where you have that many employees. Thank you for the opportunity to speak with you. Ross, I believe you're up.
Thank you, Liz. And I'm going to talk about the PPP loan program. I think everybody's very familiar with it. So we're going to kind of move into some of the technical changes that have happened over the last 2 weeks. And I'm going to let Colin to kind of jump in throughout this to make any observations that he might have on the program. And then Colin's going to talk about some of the other tax credits and programs that may be of interest in the CARES Act. You know, listening to Liz's presentation, it's frightening, I think, for a lot of small businesses about the obligations that they're imposed. And, you know, what Colin and I are going to talk about, it's money, it's helpful, but it's got only at this point, a couple of weeks of half-life to it. The Response Act and dealing at the employer and the business level with COVID-19 is something that we're going to have and we're going to be helping clients through for the next 2 years. And so I really encourage businesses to make sure that you're, addressing these issues now so they don't become tales that show up when, that employee walks in that had COVID-19 and now your entire workforce and workplace is contaminated in August, and not have sort of started to think through how you're going to manage that situation. Because we see those as business ending events for a lot of Montana small businesses. So anything that Liz and I can do to help, and Colin too, they're just such great resources. Please let us know, so we can get people managing those issues. I think in great ways, and I'm very optimistic that Montana is going to be a leader on helping REAP businesses have the resources that they need there. So, all right, with that, let's turn to the Triple P loan program. And if you have any specific questions on the Triple P, please throw them up. So, the CARES Act, which was passed just over a month ago, is the United States congressional response to the COVID-19 pandemic. It's really our only substantive fiscal response to date, except for the bill that passed last week that sort of added some money to two programs, one to support hospitals, and the second, this Triple P loan program. And the architecture of that program, it's a table, and there's sort of four different legs. One leg, which is the Triple P loan program, is now $659 billion in appropriations to support businesses. The second leg were these direct taxpayer payments, right, your $1,200. And also, I think importantly, unemployment support that was expanded to help self-employed individuals. The third leg of the table, which Colin will talk about a little bit, are some of the changes in the Tax Act and different Social Security that's available. And then the other leg, which we haven't seen a ton of attention, but we're going to start to see more about, is this $500 billion lending facility that's made available to the Federal Reserve. And so they've started to tell us what some of those programs may look like. They're out for comment, and I'm certainly coordinating with clients on how we might get those programs to be a little bit more focused and helpful for Montana. So think of that as those sort of four support legs that exist inside the CARES Act. Next slide. So the Triple P loan program is simply a loan based upon a business's payroll. And you look back and it's your average monthly payroll. Most businesses in Montana will qualify unless they're affiliated with larger businesses. It doesn't have any personal guarantee requirements, but it is capped at 10 million. And what's unique about this program is that it's expanded who can participate. So if you're a nonprofit, you're eligible, and lots of tribally owned businesses previously weren't eligible can also apply, and also self-employed individuals. Next slide. The calculation is fairly simple. It's laid out on the form. You need to calculate your 2019 payroll or your payroll from the date you apply looking back a year, average that by a month, multiply it by 2.5. There's some nuances around that calculation. I'm not going to go through those today. Next slide. I do want to talk about self-employed individuals. So we got new rules last April 15th, right? Such a tax day present. And then the Triple P program ran out of money the next day. So all the self-employed people where their bank said, no, you can't apply. They got rules. It was just cruel. Then we got more money in the program. So this is probably the people that are starting to apply, right? So you need to have your 2019 1040 filled out. That's a requirement. It doesn't have to necessarily be filed, but it needs to be completed. You're going to look at line 31. That is your payroll cost for purposes of the Triple P. You divide that number by 12, multiply it by 2.5. That's your eligible loan amount. If it so happens that you're a Schedule C earner and you have employees on your Schedule C, you can feather those costs of your employees back in. Your bank is going to need to see supporting documents, 1099s, invoices, bank statements to substantiate that you had income that matched that amount, and records that also show the business was in operation as of February 15th, 2020. You can only use the Triple P loan proceeds to pay interest, utilities, and rent, and also your own sort of profit, which is your wage. And I think I have a very particular interest in the rule that Treasury issued. They indicated that gas is a utility. So if you were driving around a lot, say as an Uber driver on your Schedule C, you're going to pay your continued gas on your Triple P loan proceeds. You also are limited in a unique way to only those categories of expenses of which you had expenses in 2019. So if you didn't have gas expenses in 2019, you can't start to use Triple P loan proceeds for gas in 2020. So I'm going to spend a lot of time on this slide. This is sort of just
catch-all of interesting things that we've seen change in the PPP loan program, and I'm gonna let Colin comment too, in the last couple of weeks that may not be on your radar, but because of the nature of this program, you might want to consider, right? The first is that the secretary has announced that if you have over a $2 million PPP loan, expect to be audited. We don't know what that means. The other part, which has always been present in the PPP loan program, but is now getting a lot more attention, was the requirement when you sign the application that you as the applicant certify in good faith that the current economic uncertainty makes the loan request necessary to support the ongoing operation of the applicant. I think this is really important, right? When I hear about a grocery store in Missoula, Montana getting the PPP loan, I look at that sentence and I wonder if they can certify. Now, when I hear about a workout gym, right, getting the PPP loan program, they're probably going to be able to make that certification. And a lot of other restaurants lie somewhere in between those two places or businesses. So we don't know what that necessarily means, right? One school of thought is that the whole intent of the CARES Act was just to keep people off unemployment, right? We didn't want to overload unemployment offices. So if there was any way at all that we could have businesses continue to operate and keep them there and that stopped any amount of layoffs, we're okay with the PPP loan program, right? A third or a fifth of the American workforce as of today is unemployed. It's probably never happened before at that level. The other thought is that really this loan program was only intended for those that were just about ready to go bankrupt. That's a whole different spectrum, right? That means that businesses where they had ability, like a line of credit already issued, that they could go weather these times, they weren't eligible because it wasn't necessary for ongoing operations. I say this because every single business that got a PPP loan program has a safe harbor. If you decide that you don't meet the qualifications, you can return your money by May 7th and avoid potential penalties. You still have to pay that little bit of 1% interest. So I think it's critical that businesses work probably with legal or tax counsel to really evaluate whether at the time they made the loan request, they were eligible under this standard.
Ross, I'd just interject to the majority of my clients, if they didn't hear it from me, didn't hear it from you, didn't hear it from their banker, they heard about this from their friends, and everybody's giving out free money. And the publicity around this can be pretty frustrating when you approach that definition. Current economic uncertainty, I think is one key part of that phrase, and the other one is necessary to support the ongoing operation. I think people so much focus on the current economic uncertainty. Certainly, many businesses meet that, but necessary to support the ongoing operations of the applicant is I think ignored by a fair number of people, and I think it needs to be stressed.
Thanks, Colin. And I should just highlight, right, if I decide to take an aggressive position on my tax return, and my buddy knows that I took an aggressive position on my tax return, my buddy can call the IRS and they're not going to come after me, probably, right? That's not the case with the PPP loan program. If I learn and I have private information that a business took these funds and got forgiveness, I think you have a right of action under what's called the anti-kickback statute. And Liz, if you want to chime in here, please do. As a third party, so I can file a lawsuit in federal district court against my buddy, alleging that he committed fraud with the PPP program. And the United States Attorney's Office will have an opportunity to either pick up the lawsuit or let me prosecute it on my own. And in that case, I'm going to get both some attorney fees and potentially a large portion of the amount of money I recover on the government's behalf.
Ross, Colin, can I maybe ask a question there? And this is a very kind of difficult question probably for you to answer, but given the clients you worked with, I mean, do you have, or the businesses that you know have applied for this money sort of in Montana and the kind of businesses we have, would you think that there's a significant proportion of those businesses that may be on the wrong side of this, that may need to think about sending the money back? Or do you think most of our businesses probably had good calls?
Yeah, it's a good question.
Go ahead,
I guess my take is I think my counsel to my clients is if we measure the ongoing operations of the applicant, that doesn't mean bankruptcy. I mean, that doesn't mean that in my opinion, and this is not a legal opinion, and it depends upon the applicant, but if the ongoing operations of the business are going to stop because of COVID related activity, they're going to lay off their employees and send them home. If they take these PPP loan funds and it allows the business to continue to operate in a normal fashion, I think they meet that definition. I think there's a fair number of businesses, and not specifically my clients, because my clients all do it right. A fair number of businesses who are going to operate regardless of receiving these funds or not receiving these funds. They're not impacted. Now, there's what my guidance to my clients who fall into that bucket is you have economic uncertainty. We don't know what the next 6 months, we don't know what the next 2 months are going to look like. When we were going through this in March, it was the phrase was a day is a year, and things change so quickly. And so just getting these funds does not, like Ross is saying, it does not mean you have to use them. You can pay them back, but it does provide you with liquidity to survive if you do get significantly impacted.
Does that sort of imply that, I mean, we've had these cases, right, of the businesses that laid off employees, then got the PPP and tried to encourage the employees to come back, who didn't want to because they were getting more unemployment. And some of those instances, like really wasn't work for them to do. So if there isn't work for them to do, they really should have stayed unemployed and should take unemployment as opposed to taking the PPP money.
Yeah, there was a proposal issued by the AICPA today that to the Treasury, they requested that they change the PPP measurement, which Ross will mention here soon. But the 8 weeks starts when you get the loan proceeds, and the AICPA requested that the 8 weeks start when the stay is lifted from your community or your state. And I think that would solve some of those issues because, right. Yeah, exactly. Somebody who gets a PPP loan funds has to go convince their employees who are getting more on unemployment to come back to work when there isn't anything to do.
Yeah, and the PPP loan wasn't necessary because they weren't going to have the employees doing any work anyway. And then exactly. It sounds like some of the high profile cases, the Shake Shacks that have given the money back, it was positioned sort of as, it was morally not good for them to have asked for that, taken the money. In a way, you're probably saying behind the scenes, actually legally, someone was saying, you probably don't want to take this.
Let me just say this, right? If I have to defend a client who is accused of not being eligible for the PPP loans, what I would like to see is an email from Colin, right? Discussing the financial situation of that client when they got the PPP loan. And then I would also like to see an email from their banker or other financial advisor saying how important this liquidity is and where it fits inside the context of the business. Also with some growth projections or sort of other financial information. This is no different than I think what Liz was talking about with documenting and managing your business's response to COVID-19. What was the financial position of the business when this happened? Show how it was warranted. And if you've done a good job documenting it, it's going to be a lot harder to say that you went out to the PPP proceeds.
I'm just going to give us a time check because we've got about 12 minutes left, and Morgan actually is going to be using the same Zoom for a follow-on meeting at 1. So
perfect.
If you want to figure out what are your kind of headline points over the next.
Yeah, absolutely. Well, let me make one more point on this side, then we'll jump forward. So embedded with the PPP loan program is it's inside the 7A loan framework. There are rules inside the 7A loan framework about payments to what are called related parties. And so I think for a lot of Montana small businesses, we have yet to see Treasury say these don't apply. So if you are using your PPP loan proceeds to pay rent to your related partnership that owns your real estate, my view is those are ineligible uses of loan proceeds, and that's going to be problematic. So I would encourage businesses to use their proceeds in other ways to avoid tripping that wire, at least until Treasury tells us that wire doesn't exist. I'm going to skip over the forgiveness slide.
Okay.
Ross, you may just mention that we're supposed to have forgiveness guidance in the next day or today. So we're hoping that comes, but everything we have right now is conjecture based upon loose guidance from the SBA.
All right.
Yeah.
Well, once we get that forgiveness guidance, maybe we can tee up another session with you guys and maybe hit some
Absolutely.
topics that we don't have sufficient time for today. So
I would note that so unemployment is now available for self-employed individuals. So if you're a self-employed individual, you have, and your income has been threatened, right? You have a choice. You can go get on Montana's unemployment, which if you're making less than $55,000 is probably going to be better than the PPP loan proceeds. And I don't know anyone that's gotten through the unemployment process yet, so I don't know how that's working or what's required or any of that in Montana. But there's a very unique tax shift if you go with the PPP versus unemployment, because unemployment is going to come back to you as a wage on your 1040. So you're going to have to pay tax on that amount. But you could potentially have it for the entire year, right? So it's got a longer tail. The PPP loan is if you get forgiveness, is going to look like a grant. And so there's not going to be a taxation consequence. At least at the federal level, we don't know yet how Montana is going to treat that. So it's worth some strategic thinking and maybe coordinating with your CPA about those options and maybe how those options fit together, right? PPP first and then unemployment. I don't know. Next slide. I'll turn it over to Colin to briefly.
they gave you 8 minutes, Colin.
Yeah, really. I think this is a perfect point, though, when you start planning whether or not, and most businesses are past the point of planning, but if you haven't applied for a PPP, you need to consider whether the PPP is the right method for you or whether the employee retention credit is the right method. So if you go to the next slide, it kind of gives you some details there. Essentially what it is you get a 50% credit on the wages you pay your employees while your business is affected by this COVID relief. So what does affected mean? It means either you're partially or fully shut down by your local or state government, or, and this is an or, not an and, or your gross receipts decline more than 50% in comparison to the same quarter from the prior year. The nice thing about this one is you can continue to claim this credit up until your gross receipts exceed 80% in comparison to the prior year same quarter. So you could claim this all the way up to the end of, I think it's Q1 of 2021. But your limit is on $10,000 per employee. So you've got to manage, if you're going this route, you could manage how you're staffing your employees so that you're getting basically $5,000 credit per employee, as it says in that last point. But important to note, this is only available for employers who have less than 100 employees in the way that I'm describing it. If you have more than 100 employees, you can only claim credit for paying your employees for non-service related. So in other words, if you're shut down and you continue to, you're a dentist and your business is shut down and you have more than 100 employees, which probably a dentist is a bad example, but you could only claim payments to them for services they're not providing. So this credit is basically for employers of less than 100 people. If you're more than 100, you get it for the goodwill you pay your employees.
Right. Colin, it seems like this one, there's essentially a financial analysis to be done that's probably is best done with your CPA, right? It's exactly. Tough to figure it out on your own.
Yeah, and it's got to be done quickly because we're not sure when the PPP loan funds are.
But it's great to know it's an option because I think it's got very little
it
coverage.
Is, and you can apply for this one. You can file a form, the 7200, with the IRS to get your credit now rather than waiting till you file your 941 or your business tax return. So you can get your funds pretty quickly.
Cool.
If you go to the next slide, there are all sorts of new provisions in this law that we're not going to get to today. A couple of the important ones are listed here. Required minimum distributions for anybody over the age is now 72, but used to be 70 and a half that I think most people are familiar with. They can be suspended. If you've received your RMD in the last 60 days, you can pay it back. We don't know if you'll have to take 2 the next year or not. Another important one to mention is if you made improvements to interior portion of a commercial building, It was always intended by and documented in congressional minutes that you were able to write off that whole amount in this year, and they didn't include it in the Trump tax reform, and that was a mistake. And they acknowledged that mistake by including it in this bill. So it's actually helpful to me to have that assurance. I don't know that other people are necessarily aware of that.
My takeaway, just sort of scanning these, Colin, is I mean, hopefully prior to COVID-19, right, the economy was going great. So hopefully there's been a bunch of businesses that have been pretty profitable in the last few years. So the ability to carry back some of the losses as well as get kind of credits on some of these other things, that's a pretty good way folks could be getting a significant tax refund.
Yeah, absolutely. Especially if we see big losses occur in 2020 as a result of this, they'd be able to carry that back and claim that refund based upon their prior taxes.
Great.
The next 2 points I think are interesting for people to know, but I think maybe time is better served with Q&A if there's any out there.
We don't have any through the chat, so we got like, what do we have, 50, just turned 57. So we got like 2 or 3 minutes if there's any kind of closing comments you want to make, Colin, or kind of Russell is.
Yeah, I guess, in my opinion, I think it's not as sexy and as interesting, but I think the Response Act, I think Ross mentioned it, and Liz, what you went over, I think is essential for businesses to know. I get calls every day, questions on employees requesting leave, and my four-person employer doesn't understand that they are subject to the Response Act, and it's happening all the time. And I thought it was interesting, the DOL actually released a couple of investigations they've done, conclusions on people violating the Response Act, and they're responding very quickly, I think, to these complaints.
Right. Yeah. No, I think this is, I thank all three of you. I think this has been really eye-opening to, as you were just saying there, Colin, a bunch of things I think people are just not aware of. So we will do our best to push the recording of this out. And actually, Liz, I really appreciate your kind of guidance through that sort of reopening piece at the front, because I know that's very front of mind. And we've, through the BEAR program, we've been sort of coordinating with some of the Missouri Economic Recovery Task Force around this. So I might even suggest we take that, we'll have the whole recording, but we might even excerpt that particular piece, because I think it's a really good sort of walkthrough and checklist, and kind of push that out, and might even ask MEP to share that as well.
Sure.
That's a great run through.
We do have other resources of other webinars recorded on our website that go in detail more through the CDC, the OSHA, temperature taking, all that.
Fantastic. Yeah, if you're able to maybe forward us some links, we'll include that at least in the materials that we post up on our website. Sure. But yeah, I really want to thank the three of you. This is fantastic information. Definitely shed a light on some things that a lot of people I think were not aware of. So we really appreciate your time and expertise. And thanks to those folks that joined us today for joining us. And we'll be back tomorrow. At least I'll be back, and Morgan will be back. We've got Mark Losh from the Missoula Chamber and Margaret Backer from the Kalispell Chamber, really talking about how do you build sort of your business relationships in this kind of environment when you've got to do a lot of it over Zoom, but building those relationships and understanding what your customers and your clients need is super important. So that's what's on the agenda for tomorrow. Thanks, everyone. We'll talk to you soon.
Thank you.
Thanks a lot.
Thanks, Morgan.